Good afternoon. My name is Tim Tormone, Associate Executive Director at the University of Maryland Alumni Association. Welcome to the webinar, Patents and Trademarks, What You Need to Know, presented by Jeff Karceski. Jeff graduated from the University of Maryland College Park in 1988, where he received a degree in nuclear engineering with a minor in mechanical engineering. Jeff graduated from the George Washington Law School in 1991. His career encompasses 3 law firms. In addition to his experience in private practice, Jeff is an adjunct professor at Georgetown University, where he has been teaching a paralegal course in intellectual property since 1994. Jeff is a registered patent attorney who has represented both small and large clients in many technology areas. While Jeff's primary area of practice involves patent prosecution and client counseling, he has been involved with the enforcement of intellectual property rights before U.S. District Courts and the U.S. International Trade Commission. Jeff also has assisted clients with re-examination proceedings and interferences before the Board of Patent Appeals and interferences at the U.S. Patent and Trademark Office. Before I turn the webinar over to Jeff, please note that if you have any questions, to type them in the questions box. We will get to as many of those questions as we can. And also, this webinar is being recorded and will be sent out to you sometime in the next 24 hours. With that said, please welcome Jeff to the webinar.
Tim, and thank you. And for everybody who's listening, I just want to kind of start out. First of all, we're going to talk about patents and trademarks today. But the slides that we have or that you're going to have available to you until we'll make the full slide presentation available to everyone from what I understand. It does include some additional information about copyright law. It's unlikely we're going to have an opportunity to get into that, but if we have some time before this is over and there are some participants that would like to hear a little bit about copyright law, I'm happy to delve into some of the basics for it if there's any interest. But the presentation today is primarily focused on patents and trademark law. So what I'm going to do is, if I can go ahead and get to my slides, I guess the first thing that I need to do, of course, being an attorney, the very first thing that I always end up doing is providing a disclaimer. So just to be really clear, anything that I say in the next hour is just purely my opinion and is for your information purposes only. You shouldn't rely on anything that I say or anything in the slides as truth. If you have a question, by all means, what you should do is go ahead and seek the advice of an attorney, because if I'm sure, as everybody knows, facts make a big difference. And while some of the rules that we're going to talk about are, for the most part, are hard and fast rules, of course, there are always things that can change, the opinion of an attorney or change the outcome for a particular fact pattern simply because of what's relevant for that particular fact pattern. So if you do have any questions, by all means, please call somebody that or of course you can call me as well. I'm happy to to speak with anyone, but don't go forward just based on the discussion that we have here. What I was also going to say is, I guess, just by way of introduction of myself, is that as Tim had said, I've been teaching over at Georgetown for quite a while. So if anybody has any questions, feel free to break in, and you can either type your message in the chat box or your question in the chat box, and I can follow up that way if you're more comfortable, or if you want to go ahead and actually ask the question out loud. That's fine too. I'm totally fine with that, and I think it helps if this is more of a conversational discussion rather than just being purely informational, but I'll leave it to everybody online as to how you'd like to proceed. So, as I said, what we're going to do today is really, and so my apologies up front for the large number of slides, because there are quite a few in this presentation, but we're not going to go through them all of them, as I said. They're really for your information. And again, having said that, what we're going to do is talk about patents and trademarks today. And what I want to do is really touch on a couple of things that I think are important. The first is, how do you get these rights? What are the procedures for obtaining these rights? I think that's a basic question that most people have. When you get these rights, what do they mean? A lot of people have some misconceptions, especially with respect to trademarks, in terms of what these rights actually cover. And then also what I wanted to do is just highlight a few things that everybody, I hope, will find interesting in terms of just some common errors that people make, inventors make in the patent area, companies make in the trademark area, or both the trademark and patent area, simply because of inexperience. And so what I want to do is just highlight a few things that hopefully, if you're paying attention to the slides and you actually end up having to contact an intellectual property attorney, hopefully you won't step on some of these little errors that can cause problems for you down the road. So having said that, what I want to do is just kind of do an overview. Now, we're going to focus on patents and trademarks, but I wanted to just point out that when people talk about intellectual property, not only are they talking about patents and trademarks, but they also are talking about copyrights and trade secrets, which fall into the big umbrella of intellectual property. Just for the uninitiated, for those of you on the call who have never dealt with this before, patents cover inventions. We'll talk a little bit about that in a few minutes. And there are multiple different kinds. We'll get to that. I won't delve into that now. Trademarks are source identifiers, like logos, names. We'll talk about that a little bit more as well. But identifying, goods and services, and distinguishing or helping to distinguish those goods and services from the goods and services that are provided by other companies. Copyrights, the easiest way I think in my years of teaching to describe a copyright is that it really covers written material, but of course it's more than that because music also is encompassed, as well as movies and audiovisual works. And copyrights prevent or give you the ability to prevent somebody from copying that material. That sounds kind of redundant. But I mean, if you think about copyrights as, it prevents somebody from taking your work, putting it on a copy machine and running off a copy, that in its most fundamental way is a very simplistic way of looking at copyright law and its protection. And I just wanted to throw that out since we're not going to have a chance to probably deal with that this afternoon. Trade secrets is a totally separate area of the law. We are not going to be talking about that today, but I did want to just bring it up. Trade secrets can cover a lot of different things. Customer lists are, one of the things that comes up frequently in the trade secret area, but it could be really anything, like some formula that you might have that gives you some benefit in the marketplace, like, an easy example is the Coca-Cola formula. But it doesn't have to be. It doesn't have to be that kind of formula. It can really be any kind of information that gives the business some advantage over other businesses. And the thing which makes trade secrets a little bit different is that trade secrets are not registered like patents and trademarks, as we're going to discuss in a few minutes, but they are protected simply because it is information that you are keeping secret by applying reasonable steps. And if you've got so many questions about that, or anyone on the line has any questions about that as we get closer to the end of the presentation, I'm happy to go into that area a little bit greater detail as well. So Tim, I'm just going to cut in real quick. I had a little notice that popped up on my screen that I might be having an internet slowdown, so I just want to make sure that you're actually receiving my voice okay.
Everything is fine at the moment, thanks.
Okay, good. So anyway, as I said, patents and trademarks will do, copyright slides are being provided for your benefit. So, intellectual property. Again, just a little bit of ground rule, but intellectual property, just as the name suggests, is property. And for that reason, it can be sold and it can be licensed or rented to another party, just like any other property that you have. So I oftentimes go through this with my class at Georgetown because people ask, and it's, if you want, you can think about it almost like your house, right? You can sell your house to another party. The same can be true for patents and trademarks. Or you can license or rent your house to another party, right? And then they would just use it. When they're finished, then they leave. And that's basically licensing in the intellectual property context. All of the intellectual property that that exists can be transferred in this manner. It either can be sold or it can be licensed like real property. So I just want to be very clear about that. Now what I want to do is start talking about patent law a little bit. And by way of introduction, what I need to kind of point out is that with respect to patent law, there are in fact 3 different types of patents that are available under United States patent law. Now the one that's number 1 on my list is the utility patent. That is by far the type of patent that is the most numerous. I put on the screen there over 9,700,000 patents that have issued. I think we might even be over 9,800,000. We might be getting close to 9,900,000. At any rate, utility patents, basically we started, our patent system started in 1789. and we've been numbering, for the most part, not exactly correctly, but because the urban legend is that there are a few patents that never got numbered. But for the most part, we started numbering our patents at number 1, and we've been numbering them consecutively since the very first Patent Act in 1789. Design patents, utility patents, just by way of introduction, they cover different subject matters, a process, which is basically a group of steps that are arranged in a particular order to achieve a particular result. This is also referred to as methods. And this includes, by the way, also software as a method. Machines. Machines are, in a very simplistic way of looking at it, are things with moving parts or multiple parts that are interacting with one another. That's referred to as a machine. A composition of matter is exactly what you think. It could be, maybe just a compound, for example, a molecular compound. It could be, groups of macromaterials. So, for example, composition of matter is, while it may seem odd, it could be like a new cookie recipe. The composition of matter being a new cookie or a cake. Compositions of matter also, just by way of introduction, can encompass living material but not humans. So, for example, I don't know if anyone reads the news. I don't even know if this was patented, but several years ago there was a scientific group that actually had created a glow-in-the-dark cat. They had spliced a luminescent gene from a jellyfish into a cat so that when you put the cat under a black light, it actually glowed in the dark. Anyway, the cat, the glow-in-the-dark cat, theoretically would be something which is a composition of matter that could be protected under the law. The last category is articles of manufacture, and this is basically a catch-all category, and it basically means anything made by human hands. So if it's not a process, a machine, or a composition of matter, but it's made by human hands, then it's protectable under the utility patent statute. Design patents are a little bit different. They are less numerous, number 1. There are only about 750,000 of those that have been issued, a little bit more than that. But they cover the ornamental appearance of something. So it's actually the exterior appearance of a particular item, such as the appearance of a car. It's always a good example, but it could really be anything. And I've seen design patents for things as, maybe far afield as, for example, a cake. I remember seeing a design patent for a cake once a very long time ago. The third category of patents is something that most people don't run into, and I have to admit in the 25 years that I've been practicing, the only ones that I've ever seen are the ones that I've actually looked up on my own in order just to see what was in a plant patent. There are only about 26,000 that have issued. Maybe we're getting close to 30,000 by now. But these cover very specific asexually reproduced plant varieties, and these are ones that are reproduced by seeds. And the idea here is that if you were to take a cutting from one plant and graft it onto the root body of another plant, that thing that you cut and grafted onto the root body, could it in and of itself be protectable under the law? So, but again, it's a very, very specific subject matter and a subcategory of patent law. And as I said, utility patents by far are the ones that are most numerous, and that's what most people think about when they think about something which is protected by patent. When we're talking about patent rights, one thing to keep in mind is that patent law is federal law only. What that means is that if you're going to acquire patent rights, you have to go to the United States Patent Office and ask for the Patent Office to grant you those rights. And the process of doing that is called patent prosecution, which is what I primarily do in my own practice. Another thing to keep in mind is that patent rights exist only after a patent is granted and not before. There are some rights that can exist before a patent is granted, but some people are under the misperception that once a patent application is filed that they have some rights. That is partially true, but for the most part you have to think about it in terms of you don't have any rights until the patent actually is issued to you. Now in order to get patent rights, you have to file a patent application, and it takes about 24 to 36 months for the patent to grant. So for the patent application, I don't want to go into tremendous detail about what a patent application is, but the whole purpose for hiring a patent attorney is for them to, or him or her, to draft the application for you, because there is no form, like to a degree in trademark law. It's not like you can go online and you can fill out a patent application and just fill in a couple of blanks. You actually have to have someone who knows what they're doing, or yourself be somebody who has studied what other people have done so that you can actually describe the invention in a way that's going to be acceptable to the patent office so that it can meet the requirements for examination and so you don't run into any problems. And that's really what the purpose or one of the functions of the patent attorney is to go ahead and draft an application for you and of course hopefully be able to get a patent for you within that patent prosecution window for 24 to 36 months. And I should say, I guess one of the other things I should say is that it is possible to accelerate patent prosecution. If you do, you can get the prosecution down to about a year, but you have to pay an acceleration fee to the patent office in one context. There are other ways to do it as well. And that fee is fairly steep. If I remember correctly, it's about $4,000 to accelerate the patent office or the patent examination process. And that fee is due to the government. That's not something that the attorney, it's not part of the attorney's fees. It's what the government charges. And I guess I should say, just by way of aside, that the patent office runs based on the fees that are generated by its users, meaning the people who are seeking patents. And so you pay a lot of fees through this process to the government, and those fees then are supporting the patent office and its various functions, employees, and infrastructure. This slide I just threw in for no reason except that occasionally I get people who ask, what does a patent even look like? So what I did was I put on the left-hand side of this screen is a utility patent, just an example. And excuse me, on the right-hand side is an example of a design patent. We know that it's a design patent because that's a little D in front of the number, so that's one way to tell the difference, just as by way of a quick distinction. Now, when we're talking about patents, one of the questions that comes up is how long are these patents good for? And patents are good for one of two different terms. If it's a utility or a plant patent, we measure the term of the patent from the filing date of the application. And keep in mind that I said a minute ago it's about a 2 to 3 year process before a patent issues. So there is a 2 to 3 year period at the beginning of the prosecution phase where there's no protection. But the duration of the patent is still measured from the filing date, and the expiration date is measured 20 years from the date that the patent application is filed. That's true for utility and plant patents. That is not true for design patents. Design patents are actually measured from the issue date, or the date when the patent actually issues from the United States Patent and Trademark Office. And there are two terms that are currently applicable because the law changed within the last 2 years, within the last year, I'm sorry. So that for design patents that are issuing now or filed now, and so they would be issuing now, the term is going to be 15 years from the issue date. So it's a little bit different than the way in which we measure the term for utility or a plant patent. So, big question. When seeking a patent, or when you want to go through the process of prosecution to actually get protection for your invention, of course a great question is, what makes something patentable? How do I know that I have something which is protectable under the law? Now the standards are a little bit different for utility plants and design patents, but we're going to use the utility patent as an example because it's the one that you're more likely to run into out of the three. And there are three requirements, there are more than three requirements I should say, but the three basic requirements for patentability for a utility patent is that it has to have utility, which is kind of circular. It has to be novel, or it has to be new, meaning it was never done before. And it has to be non-obvious. And non-obviousness is, for lack of a better way to describe this in kind of a bullet point way, is that it has to advance the technology in some measurable way or in some sufficient way that we believe that it's protectable under the law. When we're dealing with utility, what I want to say is that the threshold for utility is really low. We always define utility under the law as what lacks utility, and so I put a couple of things on the screen here. Something which is illegal or deceptive can't be protected under the law. An example of something that would be illegal would be, for example, if I wanted to patent, let's say, a printing machine that only prints counterfeit money. Counterfeiting is illegal under the law, and so that machine would not be protectable under the Patent Act. However, if that machine also could be used to just create color prints of photographs, for example, well then of course it would be protectable. So I'm not going to go into other details, but if you do have a question as to whether or not your invention has utility, by all means, seek help and try run the facts by somebody that you know. Novelty is and non-obviousness are really the major tests under the law in terms of what makes something patentable. And these are the questions that people always have when they're asking about, hey, do I have something that I can protect? So novelty is it new? And the easiest way to think about something new is that if I live in a world where I have only blue pencils, then in my world of blue pencils, a red pencil is new because I've never seen one before, okay? Or we don't have them in my world that I'm experiencing every day. So the test of novelty in a way is kind of simple because all I have to do is look around and say, is this something that was never done before? And if it's something that was never done before, then it meets the requirements of novelty. The real difficult test, though, in some cases, is whether or not the invention is non-obvious. Because now, again, we have to look at what are the facts that are involved? How is it that I'm going to assess whether something is non-obvious? Now, when we're dealing with non-obviousness, there's actually a lot of case law that can kind of go along with this. We're not going to obviously get into this, not a legal class or a legal webinar. But the real question is, in a way, how much effort went into developing the invention, right? So the real question is this, right? So if the red pencil, is the red pencil obvious? If all we did was take the blue pencil lead out of the blue pencil and we put red pencil lead in, well, then clearly that would be obvious. But if, for example, it took a team of scientists in a laboratory 5 years to develop a red lead, well, then that would lead to a determination of non-obviousness. That's maybe a simplified way of looking at it, but for purposes of today, hopefully it's helpful. Now, another thing that you need to know is that in the U.S. today, we have what is referred to as a first inventor to file system. So for all intents and purposes, this system means that you are going to be entitled to get a patent so long as you were the person that invented it and you filed the patent application first in the patent office. What this also means is that there's basically a 1-year grace period for certain activities such as offering the invention for sale or making a disclosure of the invention. That's what it means in a very broad sense to be a first inventor to file system in the U.S. And I don't want to mislead you. There's a lot more to it than this, but I'm just trying to put this on the map a little bit to try to simplify what our legal system is, and also to make the distinction between our legal system and foreign countries, because our system, in fact, is different from the rest of the world. I know, not surprising perhaps, but in the rest of the world, they follow what is called an absolute novelty guideline. There, any disclosure that you make before you file a patent application is going to prevent you from getting a patent. In the U.S., we do have this 1-year grace period for certain activities, so that if the inventor makes a disclosure and offers the invention for sale, the inventor will be okay in most circumstances. But in foreign countries, once that sale is made or once that public disclosure is made, those countries are going to forever bar you from trying to get a patent. So this goes back to what I was just saying. What prevents us from getting a patent? Disclosure is one, right? So if we disclose our invention, right, and then we wait more than a year, so that's really the other part of it, that's a problem or potentially a problem for us. So, and also if we were to describe the invention in a printed publication, that also is potentially problematic for us depending on the circumstances, right? And again, this is going back to the 1-year grace period. There's also another concept in the law, I'm not going to get into this, which is derivation. So it's possible you could make a disclosure. A third party could then, hear the disclosure and then try to get a patent. If they derive from you, they would be prevented from getting a patent so long as they derived it from your disclosure. I'm not going to get into all the details. This is where it gets more complicated, right? But again, basic rule, keep in mind, if I want to evaluate whether or not I have something which is going to be new and do I want to go forward with this process, just keep in mind, if you've made a disclosure or if you're about to make a disclosure, even more importantly, these are things that you want to keep in mind because these are the kinds of things that are going to be important when you first start talking to your attorney to go ahead and prepare and file an application. Now this next slide that I'm going to show you is purely for your information. And what it does is it kind of gives you an idea of, 1 or 2 by the way is the statute for novelty or something which is new. under the law 35 U.S.C. Section 102, and I just pulled this from the U.S. Patent Office website. The reason that I'm providing this is that it kind of gives you what I just told you in maybe a more pictorial format, where you have a grace period, and then disclosure or derivation is also an issue. I'm not going to focus on the slide, but keep it in your back pocket if you decide to keep the slides, because it's something you may want to look at if you actually get into an area where this becomes a question. At least you have a ready-made source that you can look at for your own informational purposes. Now, of course, having kind of harped a little bit on disclosure and sales or offers for sale, these are the things that tend to be problematic. So in the U.S., if you're going to be making a disclosure, right, if you don't first file a patent application, you have potentially a problem, because now you're going to trigger the one-year period to get a patent application on file. What I found is that it happens, maybe not infrequently, but I wouldn't say frequently either, that inventors that seek assistance of a patent attorney, they've made a disclosure more than a year ago, and unfortunately that then prevents them from seeking patent protection now, simply because they waited too long before they went to seek advice of counsel. The same thing can happen with sales and offers for sale, and the offer for sale is really quite important because an offer for sale could be totally private, right? It could just be you and a customer standing in a room just by yourself. But the mere fact that you're making an offer for sale to your customer can start that one-year period. So that's something to keep in mind, because an offer for sale is not going to be necessarily something which is public, because it's usually done in a private meeting. And so that's something to keep in mind that potentially could be problematic for you depending on the facts and circumstances. So I don't want to say that all of these things are absolutely a bar. There are always exceptions to every rule. Hopefully, as you would appreciate, that's basically how the law works. In foreign countries, though, any disclosure is totally fatal. So if you do make a disclosure of your invention, you might still be able to get a U.S. patent, but for all intents and purposes, you would not be able to get a patent anywhere else in the world. So the general best practice or recommended practice always is that if you're going to, or if you think that patent protection is something that you're going to want, by all means get an application filed before you start making any disclosures or before you start talking to any other parties. That's always a good first rule of thumb, is to get that process started, because then what you do is you leave open all of your options. You don't have the possibility of running into any potential issues as you go forward, and it can make things a lot easier for you, as you work your way through the legal process and are trying to get a patent for yourself. So that's my recommendation that I would make. So we get a patent. What is this patent thing going to be giving to me? What are the rights that I get? Well, the rights that I get are to prevent others from making, using, selling, offering to sell, or importing my invention. Excuse me, and those rights are incredibly broad, right, as you can see from this list. And another thing to keep in mind is that whether or not somebody knows about your invention is not really important. We'll come back to that in a second. Before I do, though, what I wanted to say is there are two ways to infringe a patent. Now, a patent is going to have one or more claims appended at the end that define the legal scope of the invention. So one way you can infringe is do exactly what the patent says not to do, right? So if you do exactly what's claimed in the patent, well, then you literally infringe that patent. That's one way to infringe. But patents also are a little bit broader than that. It is possible to do something which is slightly different or insubstantially different from what is claimed, and also infringe that patent. So a patent is not only just what it literally says, but it's also a little bit more. And if you think that you might be running into an area where you may have a question of patent infringement, by all means, you should go ahead and seek advice from an attorney, because they can help you through that process. And there are lots of bits and pieces to go into that analysis. What I was about to say was, one of the things that's a pretty broad provision under patent law is that an ignorance of a patent does not excuse infringement. So if you just start making a product and it turns out that you infringe somebody else's patent, the fact that you don't know about the patent by itself is not going to prevent you from being liable for infringement of that patent. And even more importantly, patent law provides so that if you know about a patent and you infringe that patent knowingly, you could be subject to up to 3 times compensatory damages, or up to 3 times the amount that you would get just for, if you will, ignorant infringement, right? Going back to the first category. So that kind of covers in our first half hour patent law in a nutshell. And so what I wanted to do was give everybody an opportunity, if you'd like, to ask any questions that you may have before we move on to trademark law.
Great, Jeff. I think a couple of the questions that have come up will actually be answered in the second part of the webinar, so I'm going to skip over those.
Okay.
And Patricia writes, when it says patent pending on a product, does that mean they have submitted their application and are in that 2-year period of no protection?
So the short answer is yes, you are totally correct. Patent pending means that an application has been submitted, but it also means that no patent has yet been issued, because if the patent had been issued and the party is very diligent about marking, they would then mark their product with the patent number rather than patent pending. And as I said, while there are some nominal rights that do exist, and you have to talk to somebody about this because they may or may not apply, they're very, very limited. For all intents and purposes, the person who's marked their product patent pending, it means that they don't have any rights yet. Of course, you don't want to know necessarily when their patent is going to issue, but it does indicate that it has not been protected. Now, of course, if it's an old product and it might be marked patent pending, the patent may have issued too, right? You can see that one as well. I'm assuming the product just entered the marketplace. If it's been around for a while, it could have been marked patent pending, and now the patent may have issued, but the product had obviously been put into the market before they changed the marking on the product itself. But you are correct.
And the other question, and I'm kind of summarizing here from about 3 or 4 questions, but is it a good idea to apply for a patent for a product before you try to shop around and find a potential production buyer, or should you start the shopping around process first to see if there's even any interest before you start the patent process?
So it's an excellent question. So, and it's a difficult one to answer because this all comes down to individual preference to a degree. The difficulty that I would say you might run into though immediately is if you're going to be shopping things around, it's very likely you're going to be shopping around by making a public disclosure. That's what comes up most frequently. And for that reason, I would want to go ahead and make sure that you have a patent application on file so that you can shop this around without having to worry about the question as to whether or not there's been a public disclosure. Because the disclosure, even to one person, if not otherwise under a non-disclosure agreement or otherwise protected in secrecy, is going to be a public disclosure, or arguably does qualify as a public disclosure and therefore could be problematic. So my recommendation, as always, is that if a company or a person is looking to shop something around, get an application on file first. Now, we haven't talked about this, but there are ways to do applications formally and informally, provisional versus non-provisional. And so taking advantage of the non-provisional system could actually be quite helpful, because you might be able to get something on file relatively inexpensively to at least protect you, from any disclosure of that subject matter as you go forward. But again, this is all strategy, and so definitely something to talk to a professional about. But again, basic recommendation is get something on file first. That's the easy answer. How you go about that, that's a little bit more complicated.
Okay. Those are the only 2 questions I think right now. Like I said, I think the others that have come up will be answered in the second part of this presentation.
Okay, perfect. Well, then let's go ahead and get started on the second part of the presentation. We're going to talk about trademarks now, so we're totally switching gears. And what I wanted to do with, just to kind of get ourselves started, is that there are, in fact, 4 different types of marks, if you will, under federal law. There's a trademark, and trademarks are specifically identifiers for goods. Right, so I used Apple for electronics as a simple example. Service marks, which are for services, of course, and Hilton Hotels. So Hilton is an excellent service mark. McDonald's is a terrible example in a way because it's both a service mark and a trademark. There are 2 other types of marks. There's certification mark. We're not going to talk about that in today's discussion, but I want you to be aware of it just because it is available under the law. And there's also a collective mark. Certification marks are probably the type that you would, well, both of them you run into every once in a while. Those are usually going to be like Idaho potatoes or kosher goods or something along or the real seal for dairy products. They're going to indicate some type of, that the goods or services meet some type of quality standard as a general rule. And then a collective mark usually means membership in an organization. The NFL is a great collective mark, so it just makes it really simple in terms of just defining what these different types of marks are. The ones that I'm sure that most people on the phone are going to be interested in are going to be either trademarks or service marks. Now, one thing with trademark law that's important to keep in mind is that trademarks both can be protected just under the common law, meaning that you just get rights by using a trademark, and you can supplement those rights by actually registering them with the federal government. But with respect to marks, that you just by use, the thing to keep in mind with the U.S. is that we actually will give, or you will have established rights simply by using the mark in the manner that it's suggested. So if you apply your trademark to your goods, right? So if you're Apple and you start applying the word Apple or the logo Apple to your electronics, well, then you are establishing rights that are based on that use. And as I said, you can benefit those rights or supplement those rights with federal protection. But if you're just happy with protection under the common law, you don't need to do anything more. The use of the trademark does give you something protectable under the law. Now, if you want to have the benefit of federal law, and there are lots of benefits for federal law and for seeking protection under federal law, then you can go ahead and seek protection, and you would go to the U.S. Patent and Trademark Office, the trademark side of the U.S. Patent and Trademark Office, and you would request that they give you a registration. And once you have the registration, then you're allowed to use the R in a circle next to your trademark. Before then, what you'll see a lot of people will do is they'll put like a little TM next to their mark to indicate that it's not registered, but they're using it as a trademark, or SM in the case of the service marks. That doesn't mean anything. There's no legal benefit for something like that. It's just simply a notification to the public that you're using it in a trademark or service mark capacity. Just like in the patent context, there is a process of prosecution. It's usually 1 to 2 years to get a trademark registered. It can be shorter. And there it's kind of, you fill in a form that's more likely, it's as good an explanation as any. And if the trademark office says that the trademark meets the requirements for trademarkability, then you go ahead and get your registration, which is really the slide. So again, people are like, wait, what does a trademark registration look like? So I put this on the slide. This is a University of Maryland grads, which is why I picked this one in particular, and it's for Under Armour, of course, and it's one of their trademark registrations of many that they actually have. Now, trademarks actually can theoretically be protected indefinitely. So long as you continue to use a trademark, you have rights that are protectable under the law, or are protected under the law. If we're dealing with federal trademark rights, those rights also potentially are unlimited, but you actually have to go back to the trademark office every 10 years and renew those rights. So once you get the registration, you have to go back every 10 years in order to ask the trademark office to recognize those rights for an additional 10 years. And there are a lot of particulars for that. But I won't get into all the details in this discussion because we have a number of other things actually that I wanted to get through. So when I get my trademark, so I go through the process of filing my trademark application and getting my registration granted so that I can apply my R in a circle to my mark on my goods or services. And the question then becomes, what is it that these rights are doing? Well, these rights are giving me the ability to prevent somebody else from using a mark that's similar to my mark, or of course the same, right? That's the easy one, but something that's similar on similar goods and services. Okay, so it's a similar mark on similar goods and services. It doesn't have to be identically the same, it just has to be similar. Now there are lots of things that kind of go into the determination as to whether or not something is similar, whether or not there's a likelihood of confusion. So I just kind of wanted to talk about a couple of them. I'm not going to go through everything, but I'm going to talk about a couple of them just because I think that it's helpful to understand what the parameters are for what is the scope of protection that's associated with a trademark. Right, so the first is, if I'm evaluating whether or not somebody else's mark is like mine, we look at the similarity of the mark. And this can be, lots of different things. Does it look the same? Does it sound the same? Does it mean the same thing? A famous example from many, many years ago was when Lexus US, so the car, right? So this is the trademark for the car that's made by Lexus, of course. There was actually a trademark infringement suit that was initiated by Meet Data, and Meet Data is a company that is responsible for a database that attorneys are familiar with called Lexis, L-E-X-I-S, which is basically an online database for legal decisions and other things. So the similarity of the marks was that they were actually virtually identical, right? Lexus US versus Lexus IS, they're only off by one letter, so the similarity of the marks is very high. But in evaluating whether or not there's trademark infringement or whether or not there's similarity between the trademarks, we also look at the similarity of the goods or services. And it is theoretically possible that if goods or services are very dissimilar from one another, then two marks that are in fact identical could exist in the same space. There are many examples of this. You can probably think of one, I'm sure, yourself, but the first one that comes to my mind is Champion, right? If you have ever purchased any athletic equipment, right, like Champion sweatpants or a sweatshirt, right? But there's also a Champion spark plug, right? Champion sweatpants or sporting goods and Champion spark plug, they are not the same company, but they have identically the same mark. It's perfectly fine for the same mark to be used on completely dissimilar goods because there's not going to be a likelihood of confusion, which is really the test that we're trying to evaluate. Channels of trade means, where the goods are being sold, so it's like, are they all being sold in the grocery store or not? And then degree of care refers to how much care the consumer is exercising when purchasing the goods. But the two things that I really just wanted to make everybody aware of is that when you're looking at whether or not you have a problem under trademark law, whether marks are the same or similar, where I have a likelihood of confusion, really the two primary factors that I think are good to keep in mind is how close are the marks to one another and how similar are the goods or services to one another, because those are going to be two primary factors that are going to be evaluated. Now, it's possible that you can actually use another party's trademark in a couple of instances. The first is in advertising. So if I make soft scrub and I put Clorox bleach in my soft scrub, I can advertise this is soft scrub with Clorox bleach. Now, technically, as a general rule, I would never be able to use the word Clorox in my advertising because I don't own that mark. However, because it's actually true, it's perfectly permissible under the law. Another example where trademarks can be used fairly is in comparative statements. Like, and the example I have is like McDonald's fries taste better than Burger King fries, right? McDonald's in that instance would be using the trademark Burger King. Totally fine, so long as they have, actual proof that in fact that's true, so they've gone out and gotten survey evidence to back up the statements that they make. Now, one of the things that comes up very frequently, and so these are some of the things to just kind of discuss in terms of what not to do or things to be wary of. The first is never use somebody else's trademark under any circumstances. That's the easiest way to deal with it, right? So a minute ago we were saying here's when you can. If it's in advertising or comparative statements, by all means you can check with an attorney to make sure that you're following those guidelines. Right, but the easier way to avoid trademark infringement and the easier way to avoid the problem is don't use anybody's trademark at all. And that means on your website. Right? So don't use their trademark on your website for any purpose, because that is, for all intents and purposes, trademark infringement. Don't assume that if you're going to you're going to use a mark, that simply by making a trivial change to somebody else's trademark that's going to be sufficient, because usually that's not. It's going to have to be more than just a trivial change in order to not have infringement be found. And the last one is more just a practical, for this slide anyways, more just a practical caution. And that is, when you're thinking about a product, or you're about to put a product in the market, think about your trademark early. There's never an early enough time, in my opinion, to start thinking about the trademark that you're going to use. Because you really want to make sure that you're going to have a trademark that you're going to, number one, like, something that you're going to want to protect and put some real weight behind, and possibly some finance behind as well. Oftentimes what happens, I shouldn't say often, but I've seen this happen quite a few times, where an individual or company waits until, let me go back to the previous slide, they wait until they're almost at the market before they start thinking about the trademark that they want to use. And really, sometimes that can present a challenge, because by the time they get to the market, they've already selected a trademark that they think is really helpful or really good, and then they find out only at the very last minute that the trademark is being used by somebody else, or potentially could be a problem for them. So again, that's why I say think about it early, start engaging in whether or not this makes sense to be something which is protectable, and try to do that as early as possible. The other thing to do, or another thing to keep in mind when you have a trademark, is use it like a trademark, right? It's identifying These are Apple goods. These are my goods, right? Whatever my trademark is. So if you have a trademark that you like, put it on your products. Put it on your packaging. Put it in your advertising, right? So that people are aware that this is your trademark and in fact you're using it in the trademark capacity. Oftentimes people have great trademarks and, you know, I've seen it happen a few times where they just don't really use them as much, and so that can potentially create a problem because one of the things that's necessary in order to have protection under the law is that you use the trademark. If you're not making people aware of what your trademark is, it's very hard then later to say that you have a trademark which is protectable under the law. Last but not least, what I wanted to say was that in order to protect a trademark under federal law, you have to have interstate commerce, meaning that you have customers in more than one state. So that's one of the trigger elements. So the only reason I bring that up is because if you do want to seek protection under federal law, just recognize that you're going to have, it's not just going to be use, you know, like in your local neighborhood or in your state, but it's actually going to be a little bit broader than that for federal protection, and your the person that you go to talk about trademark protection can certainly help you with that. Now there are a couple of other things that I wanted to bring up in the trademark context that I think are interesting that people may have heard about before, but they're certainly the kinds of things that come up. One is, and this happens a lot, a trade name, meaning a company name, is not a trademark. It can be a trademark if it's used in a trademark capacity, but it is not in and of itself a trademark, right? So it's funny because this happens frequently where people say, hey, I have a great name for my company. I want to go ahead and protect it as a trademark. Well, and the name of a company is not a trademark, so it may be a great company name, but unless you're going to, right, so if your company name is Acme, right, so I'll just pick that one out, clearly not going to be a good one for a company, but it doesn't matter, right? So I pick Acme as my company name. If I'm not, you know, also marking my products as, you know, the Acme computers or, you know, the Acme Roadrunner killing device or whatever, right? It's not going to be something which is protectable as a trademark. It has to be used in the trademark context, meaning that it has to be applied to goods and services in order for it to actually function as a trademark. Okay, so something that's very important to keep in mind because people trip over that one quite frequently. Other related issues that are important to keep in mind is that you can have problems with something referred to as trade dress. And of course you can be creating your own trade dress with respect to your own goods or services, right? So all of this goes hand in hand. So trade dress is a kind of a broad issue, and it is basically the look and feel that's associated with how goods and services are protected to the consumer. An example which is now very old, but it's still a very good example, is if anyone has ever been to a Fuddruckers hamburger restaurant. If you haven't, it's not a big deal. So what I'll tell you what the facts were when Fuddruckers first opened these, they had a very distinctive interior restaurant appearance. And it was like a specific color scheme. It was a restaurant layout. It was very unique at the time that they first came into business. And it's not the trade dress that they use today, by the way. Anyway, because it was so unique, it was actually the type of trade dress that a number of other hamburger restaurants wanted to copy, and in fact did. And Fuddruckers actually sued for trade dress infringement. The restaurants weren't using Fuddruckers or even anything remotely similar to Fuddruckers, so it wasn't a trademark infringement issue. What was happening was they were just using the layout of the restaurant so that somebody walking in and seeing that trade dress would have the potential for confusing that restaurant as being somehow affiliated with Fuddruckers. That's the concept of trade dress. Something important to keep in mind, right? So just because you're not infringing somebody's trademark doesn't mean that, you know, you might not run into a problem with them in terms of trade dress, and then the same is true for your own trade dress, right? Somebody might not be using your trademarks exactly, but if your business is the type that actually has a particular trade dress associated with it, it is possible that somebody else could try to trade off on your trade dress even though they're using an entirely different mark. So I just want to throw that out because that's an issue that does in fact come up not infrequently in the trademark context. There's one other issue that I think is really important to keep in mind with respect to trademark law, and that is the concept of dilution. And this applies to famous trademarks. And a good example, of course, is Apple, or, you know, any brand that we would think of that we would see basically in any city we would go to. That's a very simple example of what is famous, although the definition is a bit more broad than that. And the reason I bring this up is that it's possible that you can have dilution, you know, meaning that you are somehow doing something bad with somebody's famous trademark, even though your trademark is different and even though your goods and services are different. So you have no possibility of trademark infringement, but you could still be infringing under the concept of dilution. And there are two ways that this occurs. The first is blurring, where you're using a mark that's similar, could be on completely unassociated goods. The goods are really good goods. Doesn't really matter. They're actually very high quality. But the mere fact that you're using, and I'll have an example in a second, the mere fact that you're using the trademark on these unrelated goods or a similar trademark is potentially enough, if we're dealing with dilution, for you to have a dilution problem and potentially could be infringing under the doctrine of dilution. Tarnishment is where you're using a mark that's similar, but it's usually on inferior goods, and that's why it's creating the problem for the person that's the trademark owner. So what I'm going to do is, like blurring. A simple example would be, let's see, instead of apple, I'm going to use, I'm trying to think of a type of apple, like, I don't know, like Granny Smith apple, right? So my trademark is going to be a Granny Smith apple, and I'm using it for completely unrelated goods. Let's say they're going to be for pencils. It is theoretically possible, right? I don't think that it would happen in this case, but theoretically the idea is that Apple could come after me and they could say, look, my mark is so famous that the mere fact that you're using a mark that is an apple, even though you're using it on different goods, people would confuse with me. And so therefore I want to stop you from using that trademark. That is theoretically possible. I don't think it would actually be successful, but it is theoretically possible. Tarnishment occurs, and I have a real example for that, again with inferior goods. So great example. This was many, many years ago, but it's still a great example. Everyone hopefully is familiar with Victoria's Secret, the women's lingerie store. Well, there was a mom and pop shop in New Jersey, if I remember the facts correctly, and it was called Victor's Little Secret. So it's Victoria's Secret versus Victor's Little Secret. And Victor's Little Secret, actually, as it turns out, they were an adult novelty shop, right? So they were selling things completely unrelated to, lingerie. But Victoria's Secret was still upset that Victor's Little Secret was in business, even though the trademark's totally different, goods totally different, right? There was like virtually no overlap. But Victoria's Secret sued under the concept of dilution simply because their mark was famous and they didn't like that Victor's Little Secret was doing business using a mark that was kind of the same, and naturally because of the tarnishment concept, because they were applying that mark and selling goods that, because these goods were, because they're adult novelties, potentially had a negative impression if they were associated with Victoria's Secret, they wanted to go ahead and stop that behavior. And so that's the concept of tarnishment. Now, I had wanted to finish early, and we are almost exactly on time, right? So we have about 7 minutes left, which gives us a little bit of room for some questions and answers. The remaining portion of the slide presentation that Tim is going to have is on copyright law. So, of course, I'm not going to go through that unless you guys have some specific questions. We can kind of address it very quickly. But before I conclude, what I just wanted to say was, if you do have ever a need to try to find any resources with respect to patents and trademarks, go to the Patent Office website. It's uspto.gov. Great resource for all kinds of information. The same is true for copyrights. Go to the Copyright Office. That's copyright.gov. Again, just tons and tons of information that's helpful. So I'll go ahead and leave my contact information slide up, and now we have time for a few questions. Excuse me, I hope, before we break.
Sure. I'm going to jump back to patents for just a second.
Sure.
If there is a patent that has been abandoned, can I revive that patent in my name?
The answer is no. Unless you are the inventor of that patent, you cannot revive it.
Okay. Then, again, this is kind of a summary of a couple of questions, but some of the listeners were wondering if specific words or phrases or graphic designs, and then in parentheses they said not a logo but just a graphic design, can they be trademarked?
Absolutely. So trademarks are a huge variety of things. Trademarks can be words, they can be phrases, like just do it, for Nike. That's a good phrase. That also is a trademark for Nike. Can also just be a graphical material. So the Nike swoosh that we're all familiar with, that would be protectable. And, right, so it's a great question, because let me go back to the example that we had at the very beginning. Right, the trademark for Under Armour, the trademark that's being protected here is purely graphical. It's just the U and the inverted and the A, right, in the stylized format. That's exactly what is the protection here. And so it's entirely graphical. So graphical material by itself, and also sounds can be protected, right? So if you're familiar with like NBC, you know, the 3 chimes dum dum dum, right? That is a protectable trademark as well, right? So sounds also can function as trademarks because they can be source identifiers.
Okay. And then I had someone ask, in your practice, do you help people get copyrights, trademarks, patents, or do you sue on behalf of a client because of an infringement?
Yep. So my practice is primarily obtaining rights, is patent prosecution. That's what my the one area of law that I practice in on a regular basis. The truth is, with respect to copyrights, it's something that really an individual can do for themselves. A trademark, it definitely is helpful to have a trademark attorney, and that's certainly part of my practice, although it's a much smaller part than the patent part. But the copyright is something that, you know, an individual can do themselves. It's actually fairly straightforward. All you need to do is really call somebody and kind of get a little bit of guidance and figure it out yourself.
Okay.
So, but the short answer is that patent prosecution is the primary area that I do on a daily basis.
Got it. And then I think we have time for one more question, and
Sure.
well, maybe 2. Referring to copyrights, are postings or uploads on social media or any form of network sharing platforms protected by law?
In fact, they are. That's all part of the copyright discussion. I'm not going to turn to it because I think that'll just set me off on a tangent that might not be helpful. But the short answer is anything that you create that is text, you know, copy, photographs that you take on your own, all of these things are protectable under copyright law. And if somebody steals them from you or copies them from you, you potentially have an action for copyright infringement that you could bring against that other party.
Okay.
So that was a really broad way of answering that question. There's a lot of detail there. And whoever's asking the question, if you want to ask after, you know, the presentation is over, I'm happy to go into further detail on the phone. But it's not something which is easily answered in you know, the time that we have left.
Okay. That's actually all the questions we have at the moment. So I think we will actually end maybe a minute early, which never happens, but we're going to. So Jeff, thank you very much for your presentation. We certainly appreciate it. For those of you that are still on the line, thank you for spending the last hour with us. As I noted at the beginning, this has been recorded. And we'll send out the PowerPoint presentation along with the recording sometime in the next 24 hours to anybody that's RSVP'd. So we appreciate your time once again. And last but certainly not least, go Terps. Thanks, everyone.
Thank you.